Okay. All right. It's 5:15 on April 26th. And let's need a motion to start this ZBA meeting of notice of decision.
You don't need a motion to start the meeting. Just go to the first item.
Okay, well, first item is you, Mr. Durwood.
Okay, so my name is Durwood Parkinson. I'm a municipal lawyer in Maine, live in Kennebunk, and I've represented the town on numerous matters over the years and a number of other small towns around Maine. And normally it's not the practice to have an attorney at a zoning board meeting or a planning board meeting. But this is slightly unique because in the case of the Chandonnet appeal, there's an appeal has been taken to the Superior Court. They call it a Rule 80B appeal. So it's in the York County Superior Court in Alfred. The parties, the property owner is represented by the attorney. The Chandonnets are represented by an attorney. And so it's especially critical to have the board's decision documented in writing. Maine law is clear about that anytime a board makes a decision, it has to put down in writing in words the basis for its decision. And so ideally that's done by at the conclusion of the evidence and the board starts to deliberate. And then oftentimes what boards will do is ask one of the board members to draft the findings of fact for the next meeting. And then you come back the next meeting and you go through those findings of fact. You can change them, modify them, add to them, subtract from them so that they're really your findings of fact. And then you adopt the findings of fact, and then you have the vote, as opposed to having the vote right after the close of the evidence. Now, some towns do it the way I just said, where they just vote and then they come adopt their findings of fact afterwards. That's not as good, but it's better than having no findings of fact. And so in this case, it was unfortunate because the secretary attempted to put together some findings of fact. Those were inadvertently sent. They were never approved by the board. And so in the court case, the judge would have, in my view, automatically returned this case to you to write findings of fact. And so instead of that happening, I've recommended that you meet like we are right now and adopt findings of fact, and then they can start up the court case again, because it would have been a big waste of time to go several months and have the judge say, well, I don't see the written decision, where is it? And then send it back. So that's what we're doing. So I listened to the tape. I'm not on the board. I'm not the decision maker, but I tried to put together the reasons that I was hearing in a form that I think that the court would be used to seeing. But again, I want to emphasize, these are your findings, they're not my findings. I don't write, I'm not the decision maker here. And so those are there for discussion purposes. And basically, if it's okay, Mr. Chairman, we could start with the Chandonnet one. Is that okay?
Sounds fine.
Okay, we could start with the Chandonnet one. It just basically says that there was a meeting on February 16th to hear the appeal. It says on a de novo basis. That's a Latin phrase that means all of the evidence is decided. It's not limited to the record. The appeal of Dennis Chandonnet, and that at a subsequent meeting, that's tonight, April 26th, the board with the 5 same board members present. I just want to make sure that's clear. I'm not sure. Are the same 5 board members present?
No, we're missing one, and we have one fill-in. And you told me, Durwood, she could watch the tape and be able to participate.
And who's the fill-in then? Oh, that's you, Yola?
Yes.
Yola. And did you watch the entire tape of both appeals?
Yes.
Okay. I'm just going to take out that. I'm just going to say with the five board members present constituting a quorum, I'm going to take out the word same. And when I make these changes, I will email them to Jennifer tomorrow, and then the chairman can sign them, assuming you get through them and agree.
Okay, can I ask a
Okay.
question though?
Yes.
I'm not sure what the quorum is here. Is the quorum met without me voting? Because I'm technically an
Yeah,
alternate.
so it's four is a quorum. And so you can decide to participate or not. I mean, because you did listen to the tape completely, that does qualify you to vote if you'd like to.
Okay,
So the first part
Very
of the
voted,
findings,
so.
the first part of the findings is just the basic facts, where the property is located, the zone it's located, that it's a non-conforming lot of record, and it talks about the building permit that's being appealed. That was a December 30th, 2020, a building permit, that they filed their appeal on time, and that the appellant has the standing to bring the appeal. That's Patricia Pearson, because she owns property at or near the subject property. That separately, the state issued a subsurface waste permit on December 29th, 2020, subsurface wastewater disposal system permit. Apparently that permit is on appeal too, but that's a separate process that the state doesn't have anything to do with the town. And then basically in paragraph 8, I'm saying that the key question in the appeal is whether a septic system or portions of the septic system constitute a structure under your ordinance. That was the key question. And you remember there was a lot of discussion around that. Anything, a structure is defined as anything built for the support, shelter, or enclosure of persons, animals, goods, or property of any kind, together with anything constructed or erected with a fixed location on the ground, exclusive of fences and poles, wiring, and other aerial equipment normally associated with service drops, as well as guying and guy anchors. The term includes structures temporarily or permanently located, such as decks, patios, and satellite dishes. So there's a couple reasons that I put in here that the board did not grant the appeal. One is that it did not believe that the definition covered that the septic system wasn't covered by the definition of structure because it is not built for the support, shelter, or enclosure of persons, animals, goods, or property of any kind. That's paragraph 10. And that the broad language that says together with anything constructed or erected with a fixed location does not stand alone, and that the definition was intended to be read as a whole. This is to avoid illogical results such as any form of infrastructure like a culvert being considered subject to setback restrictions. The board also noted that the definition of subsurface sewage disposal system contained in the ordinance does not state that it is a structure, and concluded that this is further evidence of the intent to separate the meaning of the two terms. That's paragraph 12. The board concluded that the location of a septic system is governed by the DHHS, the Department of Health and Human Services regulations, and administered by the state plumbing inspector, Brett Lawson, rather than through the shoreland provisions of the ordinance. And then it says the board further noted that the model shoreland ordinance issued by the Maine DEP in wake of a case law involving another town specifically states that a septic system is not a structure. And then finally, I say the board found that there was nothing in the record demonstrating that the town had applied to the DEP for a more restrictive shoreland provision allowing a septic system to be considered a structure. You can have a more restrictive shoreland ordinance, but you've got to get permission from the state to have it. And there wasn't any evidence that that happened. So based upon the above, the board voted, and you I think voted unanimously to deny the administrative appeal. And then it's a signature line for Dan as chair. Typically that's how it's done. The chairman is given the authority to sign on behalf of the board. I can make that one change tonight or tomorrow morning and get it to Jennifer, who can get it to Dan and get it signed. And basically, I don't know if you want to take these up at the same time, but Del Sesto the Del Sesto Culver appeal was similar issue, and I wrote it up, of course, with slightly different language to reflect their appeal, but it pretty much is the same thing. Again, they have an appeal to the Superior Court, but the same rule applies that you want to have a written decision in every case. So it's up to you whether you adopt these or not. No pride in authorship here. I'm not the boss. It's not my town. I'm just trying to assist and to clean up the record as best as possible.
Okay, so anybody else have anything to add to that or questions?
I got a question.
Okay.
If a septic system is not a structure, what is it?
It could be, it's some sort of an amenity to a property. I mean, like a culvert or a tree or the ordinance governs structures. It doesn't govern things that aren't structures.
I understand that, sir, but I also feel that a septic system is in support of the people living where they are living. If you
Okay.
don't have a septic system, you can't get a certificate of occupancy.
Well, so just Roland, I think it's a very good point you make, and there's certainly two sides to this issue, and the appellant has a very good lawyer who's made a very good case. But this board voted, based on I watched the tape, unanimously to deny the appeal.
I understand that.
So
I understand that.
I'm here to try to write a decision that backs up that position.
Dan, do you want to go through 1 through 15 and get everybody's yes or no?
We've already voted on this. We don't need a vote on it again. We're just going over the finding of facts. That's all we're doing tonight.
So if everybody agrees with the finding of facts, we need to make a motion.
To authorize him to sign them.
Mr. Chair,
We make a
this
motion
is
to authorize everybody to sign this. Is that what you're saying?
Mr. Chair, this is Gordon Smith. I represent the appellant,
Mr.
Dennis
Chairman,
Shannon.
No.
Hold on, Gordy, this is Gilbert Parkinson. I mean, typically this is the board's deliberation right now. And the board can at its discretion hear you, but I'm going to advise them not to open up the hearing for any more factual
No,
information or legal argument.
No, that's not what I'm doing.
Okay.
It has to do with the specific statements in the findings that I just like to briefly address. If I may just.
I don't want to discuss. No, we've already had that. We've already done the whole. We've already been through that. So right now, I want to sign these and move on.
May I make a motion?
Sure.
Make a motion that the board authorize Dan Archibald to sign the findings of facts.
I'll second that.
Okay.
No
And
further
that's on the
discussion.
Chandonnet appeal, and then you need a
I will
separate
sign them.
motion on the
It's
Culver
on
appeal.
Shannon, so I'm
On
gonna
the-
need on a Del Sesto also.
Dan, your audio seems to be going in and out. I don't know about everybody else, but I'm having a hard time hearing you. But did you hear Durwood? He said he was looking for 2 separate motions.
Yeah.
Unless that motion was intended to cover both appeals.
No, sir, it was not. That
Okay.
was strictly for the Chandonnet appeal. I'll make another motion in just a second.
Sounds good.
Can we have a vote on the motion? I vote
All
yes.
those in favor, raise. Yes, I vote yes. Yoli?
Yes,
All right, it's unanimous.
So I'm going to write 5-0 in on that and make that change that says that there are 5 board members. I won't say the same 5 board members. And I'll send that to Jennifer first thing in the morning for Dan to sign.
Mr. Chairman, I'd like to make a motion.
Please do.
Make a motion that we allow the chair to sign the findings of facts in the, I'm going to butcher the last name.
Del Sesto.
Jeffrey C. Huh?
Del Sesto.
Del Sesto.
I'll second that.
Okay, all in favor?
Yes.
Unanimous? Okay. That's pretty much it.
Your audio went out, Dan.
All right. So if there's nothing else, we can make a motion to adjourn.
Make a motion
Ah,
we
whoa,
adjourn.
whoa, sorry. You had the ZBA. I emailed you 2 sets of ZBA minutes, and also you have the Gilia request for a continuance that you were going to discuss tonight.
Oh, yes.
Oh, yeah, I'll get the Julia. All right, so the Julia, they're requesting an additional continuance of 60 days from the May 5th hearing that was supposed to be scheduled. So they're asking for an additional 60 days on top of what we gave them earlier.
Mr. Chairman, this is Derwood Parkinson. If I could be heard on that, because I have had communication with both of the lawyers in the last week involved in that appeal.
Yeah.
It's a rare situation where the 2 sets of lawyers are in agreement that the case, the appeal hearing before your board should be postponed. That normally doesn't happen. The lawyers usually don't agree, and often don't agree, and they would like to see this postponed because they believe that there's a possibility that there will not need to be a hearing on this. And if there is a hearing, it's going to be a very detailed and long hearing and complicated for the board with a lot of issues. So it's possible, what they're telling me that within this 60-day period, the facts are going to become more clear as to what the outcome is. That may mean you don't need to have a hearing. I understand your frustration of having postponed this, I think twice or 3 times already. But I'm just throwing it out there that if you did it again, it may eliminate the need to actually have a hearing, which I would assume is music to your ears, particularly with the summer coming. And that would eliminate legal expense too, not having to represent the board at the hearing and possible court cases coming from that.
Mr. Chairman,
Yes,
I make a
Ron.
motion, we accept the request of the attorneys to postpone the ZBA hearing originally scheduled for May 5th out 60 days, but no further.
I'll second that.
Mr. Chair,
All
if I
those in
may.
favor, raise your hand.
Nope. So,
Nope.
before you vote, can we possibly get a date in there so that if Roland is saying up to 60 days, so that you don't have to meet again to set the date? Because if not, you'd have to meet to set a date, and it would be a lot easier if we just pick the date now, and then you could vote.
What's 60 days from May 5th?
So if we get past the 4th of July weekend, depending on what night of the week you want to do it on,
The 7th of July.
The same
could
time
get-
at 6?
I was gonna say, or 4th of July week sometimes is tough for people if you wanted to go until Monday, July 12th as your final date.
I'd recommend the 12th.
All right, I also say the 12th. Yeah.
Thank you, Mr.
Okay, so all those in favor to postpone or to give them the continuance?
Can I just ask one thing though, with having the end part of just one time though, does that limit us the opportunity of postponing again and sort of forcing us to have a hearing if
Yes.
they're kind of at a crossroads?
Well, they've already
No.
had one extension.
Well, we've already given them several times. Go ahead, Roland.
As far as I know, we originally were supposed to meet on this back in February, I believe. And they requested an extension or a continuance to May 5th. And we granted that. And now they're requesting 60 days beyond May 5th. And I think that's more than sufficient time. If they can't settle their differences, then put it before us and we'll make a decision and take it from there.
But wouldn't you rather be able to keep postponing if you had the option?
No. If you read the zoning
No,
ordinance,
not after.
if you read the zoning ordinance, it's supposed to be done in a timely manner. And extensions of this nature are not being very timely.
It's not uncommon for a court or a board to say final extension, but that concept is not a new one.
Okay. And then do we pick a time for Monday, the 12th?
Whatever you guys want.
5 p.m.'s great with me.
Anybody else have a problem with 5 o'clock on Monday? No? Okay, so, all right, so let's make a motion for 5
Made the
o'clock.
motion already, Dan. The motion was made and it was seconded. We need to vote.
All right, all those in favor?
Yes.
All
Was
right,
that a 5-0 vote?
I saw 5.
Thank you. What else do we need to cover?
All right. Anything else?
No, sir.
Okay,
Other than the minutes, did anybody read those?
Done.
Good job, Roland.
Make a motion to adjourn.
good.
I'll second it.
All those in favor, raise your hands.
Yes.
Okay.
Thank you,
meeting is
Dan.
adjourned.